Yes. Hello, my friends. We just pressed the Let's Go Live button over here on the back end. It's a beautiful and amazing Friday, and we're making sure the tubes fire up. Before we go ahead and get started here, got to make sure those tubes have connected themselves. Sometimes they don't do that, and we don't want your boy rambling off into oblivion, lest we have been known to happen on times. But it looks like they've connected themselves. That's tremendous news. It's an amazing Friday. We've got business to attend to. Is YouTube working? Come on, YouTube. There it is. All right, now I can see it. All right, my friends, that means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Bragg and Mercan's big mistake. This is the immunity problem that we talked about a long time ago, way before the Supreme Court ever even issued their historic opinion that says that the president obviously does have immunity. It depends what type of immunity or what strength of immunity or how it applies to different contexts, but the president has immunity. And Trump's defense made that known when he was being prosecuted by Alvin Bragg, this big fellow over here, you can see on the right side of the thumbnail. Now, he said, like an arrogant punk, that there was no immunity for the president. And guess who agreed with him? Judge Juan Mercan. And in their ransacking of justice, as they just continued to race to get Trump convicted of a felony so that they could use that as leverage in the 2024 election, well, they were dead wrong. The Supreme Court and came back and agreed with our interpretation of the Constitution and said there is clearly immunity. And because Trump anchored it in, because in the pretrial process, Trump said, hey, you better pause this. You better pause this whole situation here. And because Bragg and Mercan did not do that, Trump is saying that's catastrophic error. And now this entire case needs to be dismissed. And that's pretty good news. So we'll read through it. It's a 55-pager. So we're going to spend the bulk of today on it because I think it's very important. And it also talks about, well, it specifically references E. Jean Carroll in that case as well. But it is also something I think is going to apply to the other cases. And so I'm watching in the chat. Did the Baldwin case get dismissed? Are you kidding? Or is that happening right now? Anyways, I don't know. Don't pay attention. Okay, we're here talking something else other than Baldwin. Anyways, it was just dismissed with prejudice? Okay, holy crap, that's crazy. All right, hold on. Let's just pause and see what the hell happened over there. So how did that happen? Baldwin walks, special prosecutors. Here's the state's case is imploding. Let's see what Good Lawgic says. Good Lawgic is, of course, doing some great coverage over there. He says Baldwin trial's about to be dismissed. Oh my gosh.
Wow.
This is crazy.
Oh, you'll never see this again. You will never see this ever.
What happened?
Ever again.
Wait,
what
I
happened?
want to keep watching.
Yeah,
I want to keep.
Hey, what happened? What happened?
My fault.
What happened?
Oh, my bad. Sorry.
Whoa, that's crazy.
Yeah.
I don't even know what happened, but
Alec Baldwin may be an arrogant prick, but nothing compares to a crooked prosecutor.
yeah, I don't know what the heck's going on over there, but man, I'll tell you this. Those four people have done some incredible analysis all day. I can just guarantee it. All right. So amazing. I don't know what happened. Baldwin goes free, huh? Corrupt prosecutors strike again. Incredible. Prosecution failed to disclose evidence. You're kidding. Weird. I wonder what happened. Brady issues. They didn't disclose any evidence. Crooked prosecutors is right. Isn't that fun? So, well, shout out to these people who've been doing some great analysis. Andrea Burkhart, obviously uncivil law. We got Good Lawgic. We got Danny on Direct in the house. Brady violations, corrupt prosecutions. Hey, you know, what's interesting is Alec Baldwin gets his case dismissed when there's corrupt prosecutors. You know who doesn't get their case dismissed when there are corrupt prosecutors? Donald Trump. Isn't that interesting? Fani Willis is one of the most corrupt people who's ever walked this planet. And the case is just going on. The case is just fine, right? Nothing happens there. But you have one corrupt prosecutor here, and it's weird how suddenly prosecutors are suddenly corrupt. Failure to disclose evidence. Does that happen to like a regular defendant in an everyday criminal case? No, of course not. Why does it happen with Alec Baldwin? Huh? Happens. It's weird. It's almost like they kind of engineer stuff like that. It's like, no, we're going to kind of make a reason for this to go away. Did the other gal's case get dismissed with prejudice because they failed to disclose evidence? No. Is it going to go back? Are they going to get her case opened back up? Interesting. Yeah, very interesting. Now, obviously, I haven't watched the case at all, but the likelihood, well, in general, homicide cases where somebody dies, here's my hot take on this. Homicide cases where somebody dies don't get dismissed because prosecutors goof the case up. Okay? It doesn't happen. They're like the most important cases. And they failed to disclose evidence on top of that. I don't even know what the evidence was, but it feels like, come on, guys. Come on. You want to talk about hiding evidence? You want to talk about disclosing evidence or these other Brady violations or whatever? Take a look at what happened in, sorry about that, Good Logic. Uncivil's not here, so we'll just take a minute. Hey, we're filling in for Uncivil right now. Hey, everybody, don't forget to come and subscribe to Uncivil Law, all right? Come check out our channel, Uncivil Law. We're filling in. We're guest hosting while Uncivil's taking 5. So the point is, it's very convenient. And will you please go subscribe to this is Good Logic. Will you please go subscribe to Good Logic? Can we get him over 100,000 right now? Can we please do that, everybody? If you're watching this right now, let's just pause. Let's just pause here. Let's get that link. This is live right now. We're supporting our brother live right now. So let's go over there and just get him a nice, let's boost him over there. Do we have a link to Good Logic? Let's boost him up, man. All right, let's put the link. I'm gonna put the link to Good Logic's in the chat. Good Logic's channel. And we have to do it. We're not moving on, actually. We're not going to move on. We're not moving on. The show's not moving on until he gets over 100,000 subs. So somebody better go over there. All right, let's go. Let's go, my friends. We have to. We have to do it. We have to do it. All right, here it is. Why, oh why, is my screen blurred out? I'm not happy about that. It looks like my internet bandwidth is going down. All right. Let's go. Let's go. Let's go. Let's go. All right, we're linking it. If you're already subscribed, subscribe harder, okay? Subscribe harder. Yes, let's go. All right, here, let's turn it up.
Yeah,
sets,
these
right?
rounds didn't come from
Yeah,
text. So
these
these
rounds
rounds didn't come from text.
Yeah.
There we go.
Congratulations,
There we go.
Congratulations, Joe.
All right, baby. We did it.
Ladies and gentlemen. Ladies and
Thank you
gentlemen.
so very much.
Thank you
We
so
did it.
very much.
Well, now you're about to crack another. Well, now you're about to crack another.
God bless every one of you. Thank you so much for your subscriptions. So much for your subscriptions, your support. I really appreciate it. I just want to. Well, we're going to come right back to the trial. Don't worry. But I just want to tell you that yeah, from the day I started streaming and doing this, I've had tremendous support in ways that are both immeasurable and impossible for me to aptly describe. Not simply the numbers being far beyond anything I actually deserve, but the emotional support, the constant outreach of people reaching out to me, pushing me to go forward, and frankly financial support in ways that far outstrip numbers a channel my size ever really deserved. So first and foremost, I want to thank each and every one of you who has been following me, whether it's following me for a couple of days or now 3 years or so. So I want to express my gratitude to each and every one of you. And I also want to express my gratitude to all the phenomenal people I've met in this sphere. Really a great number of people who are just nothing but love. I mean, just amazing people. You've seen them. You know who they are. So each and every one of you who I've met on either a social level or actual social type of level, I just want to tell you, I really appreciate that. I also want to thank my family for the support, because they've been really supporting in every way possible, and most importantly, God. So I just want to express my gratitude to God and ask for His continued blessings in abundance, because
Amen.
Yeah, I'm very overwhelmed, as you can see the numbers here like continuing to surge.
Yeah,
it's really it's very overwhelming. So I want to say thank you, and I hope to continue providing content that people appreciate. I'm going to keep doing this as long as I can. So thank you all, and again, thank each and every one of you for participating here. You guys are phenomenal, and in respect to this trial, I really enjoyed it a great deal.
We did it, Joe.
Yeah, it was fun.
We did it, Joe.
And I just want to also mention so many people out there who I never met before, who are actually pushing others to come subscribe to my channel.
Yeah.
It's an amazing. You guys are amazing. So
Nate the lawyer's back and a little late to the party.
Press plum
There
friends.
you go.
We love you, Joe. We did it, Joe. We love you, Joe. He's a good dude, my friends. Thank you for doing that, really. He's a good channel. If you haven't actually watched anything, you should. He puts together really good analysis, and I'm sure you will. So Joe deserves it, and shout out to everybody who made that happen for him. And we did it together live. We did it, Joe. He does really good stuff, so really check him out. And we've been friends for a little bit now, talk to each other through ups and downs over the YouTube trials and tribulations. So I'm really glad that he's here, really glad to be in good company with him. And so 100K for Joe. We love Joe. Shout out to Good Logic and Uncivil, Andrea, Danny Ann, and Nate the lawyer, of course, all making it happen, as well as everybody else. So good stuff. All right, that was fun. Okay, how cool. All right, so shout out to Joe. And apparently, Baldwin is also free. Baldwin's a free man, I guess. Okay. That's convenient. Isn't that fun? So I guess Baldwin, that's the end of that. Now, it's very interesting. It's very interesting how some defendants get corrupt prosecutors, and the government prosecutors, their corruption matters. You see how that works? The government prosecutor's corruption matters because it's Alec Baldwin. Doesn't matter if it's Fani Willis, who is paying her lover $700,000 to fake evidence against Trump. Doesn't matter at all. If Jack Smith and his thugs were threatening defense attorneys with different things, and the list goes on and on. It's wild. But if they hide evidence or falsify evidence, Alec Baldwin goes free. Trump does not. Bannon does not, right? These other people where they have illegal subpoenas and stuff like that. It's just wild times. So anyways, I guess the double standard of justice lives on. Incredible. Well, we got other business to attend to, but now we have that. And we have, Joe's getting a bunch of shout outs over there, man. Super fun. So, all right, cool. And amazing. So super fun. And thanks, guys, again for participating in that. That was a lot of fun. Joe's having a good time over there, I think. Yeah, all the congrats. You guys are great. So sending him congrats and stuff. Man, that's amazing. It's like people in the chat, like, I got tears in my eyes. It was so great. We love it. That's so great. So thanks, guys. Really, honestly, thanks for doing that. That was super fun. That's kind of it'll be a special moment. So, all right, now, the hell are we talking about today? Oh, yeah, we got business to attend to. They made a big mistake. They made a big mistake, baby. And it's all about immunity. And so we're going to talk about that today because we have a major drop that came out. It's a 55-pager. We're going to go into it and talk about it. Now, before we do that, I want to mention this morning we had a great members only stream. That's where we were. We had talked about 2 issues this morning. And by the way, I also want to say that we had a great conversation today. So our members only stream this morning was a little bit late, but that's because we had a beautiful conversation with our friend, Stephen Gardner, who is right next door on YouTube and Rumble and all across the fruited plain of the interwebs as well. And we had a talk about Biden's presser and about an update on some of the criminal litigation going on against Trump. And so if you're not already subbed to his channel, might want to check his out as well, because when that drops, it's going to be a great conversation. And so we'll check that out as well. But this morning after that, for our membos, we had a members only stream, and we talked about the rage. There were some very fun clips of people raging last night when Joe Biden was saying, "My Vice President Trump." People just lost it. And we had a couple clips, I think, from Hassan and some other people. And they were just, no, everything's fine. It's a weird time to be a Democrat. It's kind of a transition time. They're trying to figure out who they are, identify their presidents. Some people have different president nouns than other people have different president nouns, and they're just very confusing. It's a dynamic situation. Are you a Biden Harris? Well, I'm not real sure yet. I might be a this or that. I might be a Harris Newsom. Oh, how do you identify? I don't know. A Harris Biden? A Harris Obama? A Harris Newsom? I don't know. Anyways, complicated. So we talked about that. We also talked about how furious Democrats are angry with each other because some of them are secretly acknowledging that Trump is not a danger or a threat to democracy. Isn't that convenient? They all know that if you ask about the indicia of dictators and dictatorships, who has more of the check boxes checked? Is it Joe or is it Trump? I think we know who it is. And so we had those two segments this morning. If you missed those as a membo, whether you're on YouTube or on Locals, those will be out later on this weekend. And so stick around for those. If you want to join us when we do our membo only streams, including our Saturday stream, which will be happening tomorrow, come and join us watching thewatchers.locals.com or on YouTube as a membo. We'll be grateful to see you there. We were 1 hour late today, yeah, because we were streaming with our boy Stephen Gardner. It was a lot of fun. All right, and so without any further ado, my friends, let's get to the actual major filing on the day. It's a 55-pager. I want to spend some time on this because it is a doozy. And so let's get right into it. Alvin Bragg and Juan Merchan made a big mistake. They did not consider presidential immunity in the prosecution of Trump. And the Supreme Court said, you guys should have done that, because immunity is something that is applicable to the presidency. Obviously, everybody knew this. The reason why they didn't want to consider it and allow it to be something that paused this underlying case is because they wanted a conviction against Trump. They were going to do everything that they could to get it. And now it's coming back to bite them in Alvin Bragg's booty. So we're going to talk about this motion. You can see it's a 55-pager submitted in the case by President Trump. So this is from his defense team, and it is a good one. We're going to go through it in detail today because I want to make sure this full thing is on the record. Here's the table of contents. You can tell us or see that they're telling us that we're going to go through a bunch of facts here, because if you recall, what the Supreme Court said is that we have really these three buckets of conduct. So you can have this type of conduct, or this type of conduct, or this type of conduct. You can have conduct that is official presidential actions, stuff that is codified that the president can do in the Constitution or in the law. We'll put that in this bucket. So we'll say maximum immunity goes this way. So maximum immunity. You have more immunity this way than this way. You have things that are absolutely not official acts. Okay, so this would be like something like going out, shooting somebody on Fifth Avenue or something, or like having a Navy SEAL execute someone else, right? That's not really what they're supposed to do. You don't have the official authority to do that. That's against the law. That's obviously unofficial. So that would not be something that you could be immune from. Then you have this in the middle where it's kind of conduct that might be in the outer perimeter of official conduct. We really don't know. And the president can make a good argument, and there's a strong presumption, is the word that we use here. There's a presumption of immunity. So if it's in this bucket, it's most likely immune. We don't really know. But at some point, you got to figure out where the evidence goes. Which bucket does it go into? And you need to have a hearing in order to do that. So you can present evidence and then drop them in the buckets. So as we go through this, they're going to give us a bunch of facts here and a bunch of evidence that goes into this bucket, the official category, right? It's all official. It's talking about Oval Office business. It's talking about Trump's communication about the presidency. It's all stuff that is clearly presidential conduct. And this is the Juan Merchan Alvin Bragg prosecution. We had Michael Cohen and Stormy Daniels in here. We had all sorts of questions about whether Cohen was doing legal work for Trump in 2017 when he was the president. We covered the whole trial here. We had Madeleine Westerhout, Oval Office director, who testified in this about the Oval Office. We had Hope Hicks, White House communications director, doing the same thing, talking about official presidential stuff. So it's all official, and Trump's team is going to hammer this home. You'll see. We've got all of this stuff being labeled here, and we're going to go through the facts in detail. Then we'll talk about the discussion, why Alvin Bragg violated the federal Constitution by relying on this stuff. And as we go through this, we're going to ask ourselves, how is this going to apply to Chutkan? Because we're going to see the similar arguments pop up here from Trump's defense. How does it apply to the J6 case? How does it apply to the Florida classified documents case? And even the E. Jean Carroll case, the grabber by the purse situation that took place in the Bergdorf of the Bergdorfs. So we have a lot to go through, and you'll see Trump's defense comes out with fire. All right, Judge Juan Mercan. And remember, the backdrop here is you have to submit a little permission slip to the judge. This judge, Judge Juan Mercan, is the same judge who made 2 donations to Joe Biden. They were small spite donations, and he did it the next day, fired another one off. His daughter is somebody who raised $93 million for Democrats, has on her website that she works for Joe Biden and Kamala Harris. Daughter says daddy doesn't like Trump's tweets on podcasts when she's ranting about what she does to help Democrats. So all of this is now going to the same judge. They asked for a permission to submit this full brief. Judge Mercan has granted that. Now we start. All right, Judge Juan. So they're asking the guy who wrecked the case to reconsider or to do something about him wrecking the case. You see how that works? So we'll see if he's really amenable to those arguments. Finally, Rob, get started. President Trump, Juan, respectfully submits this motion to dismiss the indictment and to vacate the jury's verdicts based on immunity. We know the case came back down from the Supreme Court of the United States, and you need to consider that now. They tell Judge Juan and Attorney Bragg, they say, all right, buccos, no president of the United States has ever been treated as unfairly and unlawfully as Bragg has acted towards President Trump. All done in connection with a biased investigation. This extraordinarily delayed charging decision that they dragged out forever, and this baseless prosecution that gives rise to this very motion. Saying these politically motivated actions are prime examples of the type of factional strife that the framers intended to avoid. It's one-sided lawfare that risks enfeebling the presidency and our very government, and the establishment of an executive branch, if you do it this way, that's going to cannibalize itself. Now, previously abstract risks, these fanciful ideas that there would be some local hostilities that would give rise to the targeting of federal officials has happened now. We used to think this was like crazy. Okay, like, yeah, some prosecutor, some local prosecutor is going to prosecute some president. Okay, yeah, right. Well, guess what? We're here. Now, it's part of a concocted, concerted, but unsuccessful effort to stop and hinder Trump's leading campaign in the presidential election. And it's to also restrict his constitutionally protected speech, not only Trump's speech, but our speech as well. Now, they continue with this very old and important adage that you have surely heard. Says, haste makes waste. If you go fast, you screw up. It's an old adage. And it survived so long because it's right so often. Coming from the Seventh Circuit, they're quoting them. They say, like special counsel Jack Smith, who's not even a lawful special counsel because he's illegally appointed and unlawfully appropriated. Like him, though, Bragg, Alvin, is insisting and did insist on proceeding on a highly expedited basis. He wanted to go fast. Why? Well, election interference. They had a mission. It was driven by President Biden and his associates like Matthew Colangelo. Rather than wait for the Supreme Court's guidance, no, they could have waited because the Supreme Court was deciding all of this in real time. The prosecutors scoffed with hubris at President Trump. Immunity for you? And insisted on rushing to trial despite the fact that no court has ever been faced with the question of a president's immunity from prosecution. Never come up before. Andy McCarthy did some research on that. You know who supported him? Turley. You know who supported him? Rifkin Jr. You know who supported him? Many others, like Elizabeth Price Foley. So there's a lot of details here. No president has been criminally prosecuted before. They're going to come out and scream that Donald Trump's a dictator when they've got 4 open criminal prosecutions against the man, all coming from the White House? Demonstrably. Okay. Now, Bragg urged this court, you, Judge Juan Merchan, and you did it, to front run the Supreme Court of the United States. Love that line. You tried to get ahead of them. It's like, okay, you know mom's coming home, so you have to get this done before mom gets home. Because if mom caught you doing this, she would stop you and you'd be in big trouble. But if you get it done before mom comes home, then maybe you get away with it. Maybe mom doesn't know. Maybe it's all done. You say it's all closed, whatever. So no, but Bragg urged this court, right? They were trying to conspire to deviate past the Supreme Court. And they did it not on some sneaky case, on a federal constitutional issue. First of its kind novel, with grave implications on how the federal government works and how the balance exists between the state and federal officials. But guess what, Judge? And he's really talking to the judge also. He's not going to condemn or scold the judge here. He'd love to. We'll do it for him, but he would love to. He can't. But he's going to come down on Alvin Bragg. The record's clear, Judge. The judge allowed the record to happen this way. Says that Bragg was wrong. Very wrong. And what he's writing there, you can't read it, but it's a dead eye right at him. He's looking at you. He's doing that right now. As he was writing, I'm looking at you, Judge. Bragg was wrong, but you were wrong too. Very wrong, buddy. Let me explain why. Now, be that as it may, Your Honor now has the authority to address these injustices. We'll see if he does, since he allowed them to happen. But the court, okay, you have the authority, but guess what? Doesn't matter if you think you don't or whatever. You have no discretion here. In fact, it is now mandatory. You are duty bound to do so because the Supreme Court said so. Under the Supreme Court case that said that Trump does have immunity, Bragg violated the presidential immunity doctrine and the supremacy clause. Well, how did he do that? Well, he relied on evidence, all of it relating to Trump's official acts. We covered the whole trial here at length, thanks to our friend Matthew Russell Lee, Inner City Press presiding, who gave us some very good details on what was going on inside there. And we know they were talking all about stuff that Trump was talking about in 2017 and 18. Who was the president in 2017 and 18? Donald Trump. They knew that. Trump said, I was the president. I have immunity. And they said, no, you don't. We're going to trial. Trump said, this is unprecedented, okay? This is unfounded. Never happened before. Objectively, has never happened. So you can go back to the leftoids who say, well, Trump has done historic things. Never happened. So no other president has committed more criminality than a false business record. Is that what we're talking about? Much of the unconstitutional official acts evidence that they introduced unlawfully concerned actions taken pursuant to the core executive power where absolute immunity applies. That furthest bucket on the right. Now, overall, right, so in other words, the evidence submitted at trial was in that bucket, and you're not allowed to submit that evidence in that bucket. Overall, the impermissible official acts evidence included a bunch of stuff. Here is what the president does. President Trump's private conversations with the White House comms director, Hope Hicks, observations by the director of Oval Operations, Madeleine Westerhout, about Trump's preferences and practices in the Oval Office. Remember, she said, can you call Melania? Tell her I'm going to be a little bit late. And we thought, what a nice husband and a good man. Even tells Melania I'm going to be late. Oh, she's going to kill me. I'm late again. I'm late again answering more calls. He's like, I'm trying to make America great again, honey. Sorry. With respect to national security matters, also talked about Air Force One and Marine One, as well as secure calls in the White House Situation Room, all came in as evidence. Allegations of conversation about the pardon power. Official communications by President Trump using a Twitter account that was the formal channel of communication. All of it came in as evidence. Now, because of the implications for the institution of the presidency, allowing this to happen. The use of official acts evidence was a structural error in this case. Should have never come in. All of that bucket should have been left out, long out. So it was critical. The whole trial's broken. Sorry. They should, just like Judge Chutkan did on the January 6th case, they should have paused it. That's how you avoid the structural error. You don't continue on with the case. You pause it like she did. Because she knew if she continued on and the Supreme Court came back down, her case was done. So she paused it. It went up to the Court of Appeals. Jack Smith tried to leapfrog them and accelerate it and tried to really rush this thing. They came back down and said no. So then it goes back down to Chutkan. Now we're going to go back down for an evidentiary hearing. So she will remedy the structural defects if there are any. And there are, because the indictment is filled with them in that case. So the same thing is happening here, except they just kept going. Like, it's okay. Will she hold? Can we hold this thing up long enough to make it work? Will it get us home? And no, answer is no, it wouldn't. Sorry. These transgressions from Juan and Bragg resulted in the type of deeply prejudicial error that strikes at the core of the government's function, cannot be addressed through this harmless error analysis. And this is the catch-all case that the government always, it's harmless error, it's not structural, it's just kind of doesn't really matter. Okay, we had all this evidence that came in about Trump's immunity and that big long list of stuff I just detailed here. It doesn't matter. No, it was not consequential testimony, so it didn't matter. We'll get him anyways. Saying you can't even use that analysis though. Like, you can't say that. Why? Because it's about immunity. And as we know, immunity is not something that weighs the evidence. It precludes you from going through the process. It's if you're asking how the evidence is and whether this can come in and can't come in, or how it matters, or whether it's harmless or not. Like, did it influence the jury? Did it cause the jury harm to hear Trump's White House comms director, Hope Hicks, talk about Oval Office conversations? Did it harm them? The judge will say, no, it didn't harm him at all. They could have come to their same conclusion that he's guilty on 34 counts and we could have called it a day. And they say, sorry, you can't, doesn't matter. Okay. Harmless error is not about, immunity doesn't reference harmless error. It's about whether it comes in or not, because immunity means you have a force field against all of that. You have a force field against the process itself. So you can't use harmless error, which they'll attempt to do. So this is a pre-buttal, which is brilliant. Now, even if it were otherwise, which they'll probably try to say, Bragg's proof could not even withstand that test if we had to use that test. This case turned on a single witness, convicted perjurer called Michael Cohen. Clearly concerned about the credibility of Cohen and their other financially motivated star witness called Stormy Daniels, that porn star. One is a serial perjurer with an axe to grind, that's Cohen. The other is hellbent on recasting her fictitious narrative, that's Stormy, in an even more nefarious terms. So they concocted, Bragg's office, a dubious theory of a 2018 pressure campaign by President Trump, so that they could falsely claim to the people on the jury that there were people like Hope Hicks, comms director for Trump, and Madeleine Westerhout, the Oval Office director of operations, provided some measure of corroboration for testimony. And the prosecutors themselves even struggled to credit them. So they say, listen, at the bottom, Your Honor, Judge Mercan, the pressure campaign theory that Bragg's office tried to concoct was done to assign criminal motives to Trump, saying he orchestrated this. And they were related to actions that he took as commander-in-chief. All of that goes into the final bucket. The decision, which means absolute immunity, or at least, if not that, arguably in the middle bucket. So the decision in Trump, which is the Supreme Court immunity case, forecloses inquiry into those motives. That was a part of the decision in the Supreme Court case. If you have immunity, you have immunity. You can't go into somebody else's mind from afar and have some prosecutor say, well, one of the reasons he did that is because he was trying to hide evidence of another crime, because they would just say that every single time. If you could just peer into someone's motives and just ascribe them motives, of course they're going to say, well, you did something illegal or you wanted to do something illegal. So that cannot be the standard because it's not something that functions practically. So the Supreme Court said, you don't do that. And the objective inquiry required by the Supreme Court places this evidence squarely within the category of the official acts. And that means unreviewable discretion of the president. The separation of powers argument comes back. If the courts or Congress or some hack prosecutor somewhere can invade on the president's rights to execute the law according to the powers of the presidency, then they are the president because they can subordinate the president to their will. Now, the Supreme Court decision, as they said, applies equally to all occupants of the Oval Office, regardless of politics, policy, or party. So in order to vindicate the presidential immunity doctrine, Judge Juan, and to protect the interests that were articulated by the Supreme Court, the jury's verdicts must be vacated. All 34 of them need to go bye-bye, and the indictment has to be dismissed. Now let's talk about the facts and zoom in on this. Let's, before we even get to the trial, talk about pre-trial litigation and how bad this entire case was. All right, Judge, on February 28th, as you know, the Supreme Court granted cert to Trump versus United States. So February 28th, the Supreme Court was saying, we have an issue we need to decide. Question, whether, and if so, to what extent does a former president, aka Trump, have presidential immunity? It's involving official acts. Now, less than a week before that was granted, Bragg, all right, so Bragg, less than 1 week before that was granted, Bragg had already previewed their intention before the trial was getting started to talk about that pressure campaign, saying President Trump enacted some pressure campaign while he was in office in 2018. So Bragg starts it. Then Supreme Court grants cert. We're going to talk about your presidency. Supreme Court says we're going to consider how this works. So then on March 7th, just 6 business days after the Supreme Court's decision to grant cert, Trump filed a motion to exclude that. He says, you can't do that. You can't talk about official acts, Bragg. So to be clear, Bragg goes first. Then SCOTUS goes second, says, we're going to accept it. Thanks for coming in. Then Trump responds and says, no, you can't say that back. You can't actually talk about official acts because the Supreme Court is going to answer the question about whether I have immunity about those acts. They asked specifically for an adjournment, just like they were granted in Judge Chutkan's case, so that the Supreme Court could first address the issue in Trump. And again, the reason Chutkan granted the adjournment, she did not want to do it, man, but she had to, because that's how it works. And Maran didn't do it, so he done goofed big time. The president requested, in his filing, Your Honor, we would like to have an evidentiary hearing outside the presence of the jury. And they nailed it, man. And they argued the court should, quote, preclude evidence of Trump's official acts at trial based on presidential immunity, which is basically exactly what the Supreme Court said. So it's like, man, swish on that one. Well done, fellas and ladies. All got that submitted. And that's basically what the Supreme Court said exactly. Which I even, I think it's kind of a weak thing because we'll still have all these evidentiary hearings now, I guess. I think they'll probably tighten it up when this inevitably goes to an appeal. But for now, okay, they recommended an evidentiary hearing. Now they even have the argument, which is even stronger, I think, and they use the word official acts, like they're quoting themselves, and this language mirrors the Supreme Court language. It's beautiful. Because that's how it works. Now, President Trump specifically challenged the admissibility of the evidence. So before the trial started, Trump was objecting. They overruled him and let it all in. This is why it's important to object and to anchor in your positions early. 2018, they wanted, you can't use these. You can't use these social media posts where Trump used his Twitter, now X account, don't ban us, Elon, which was an official communications channel during his presidency. They used all of it, all of the president's official communications. No, SCOTUS said that's the final bucket. President Trump's public statements came in on official premises and during media appearances. We want to keep that out too. They want to keep out documentary evidence, including official forms, Form 278E, which Trump's team filled out in 2017, which is a financial disclosure report, which President Trump signed in May 2018, and they submitted to the Office of Government Ethics. So Trump was complying with the ethics, right? And they submitted that. Testimony at trial relating to official acts, including Hope Hicks and Michael Cohen. And Michael Cohen, hopefully they tell us, even admitted that, I'm sure they will, that there was legal work that he did for President Trump when he was the president, not in 2016 before he became the president. Now, as to the timing of the motion, President Trump pointed to the Supreme Court. They said they just accepted our case. And so you should stop all of this and don't, or you can continue the trial, your choice. You can stop the case. If you really need this evidence, let it go up to the Supreme Court. They'll come back out, tell you what to do about this evidence. Then we can have an evidentiary hearing and go through it. But if they had to do all of that, well, they wouldn't have gotten their verdict. So they just did it, and they included the evidence as well, which is also very problematic. So they just included most of this, as we'll see. So in March 2024, Bragg argued that the motion was untimely and was meritless. So you cannot, he says, too late, trial's right about to start, and also you don't have immunity anyways. Bragg said that there's no categorical bar to using evidence of immunized conduct when the trial involves non-immunized conduct. So Bragg's trying to make a distinction that's not in law, and the evidence at issue was not constituting official acts. And so the court denied, right? The court agreed with Bragg, and the court noted, right? This is where Merchan screwed up big time, the judge. The court declined to consider, didn't even consider whether the doctrine of presidential immunity precludes the introduction of evidence of purported official presidential acts in a criminal proceeding. Not even going to consider it. Because I don't think these are official acts. Turns out you should have done that, Judge. Should have considered it, should have had an evidentiary hearing on it, or stayed the case, or precluded the evidence. But he didn't want any of those options. He wanted all the evidence to come in. He wanted the conviction now. And he didn't want to hold a hearing about it. So he screwed up 3 times. So then President Trump appealed that, right? So the judge comes out, denies it. Nope, all the evidence is coming in. We're not stopping anything, full steam ahead. So Trump appealed. Now on April 10th, President Trump filed a verified appeal. On the same day, they denied us an application for a stay. They were just saying, hey, can we just pause it? Judge Chutkan paused it for immunity. That was the right thing to do, but they wouldn't do it. In its opposition filing, we have redacted items here. I don't even know what it is. But Bragg claimed that so on and so on, and Bragg argued that so on and so on. And finally, Bragg said, blah, 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 blah. All of these claims have now been explicitly rejected by the Supreme Court. I don't know what those claims were, but Bragg's probably whining about something. But on May 23rd then, the first department, the appellate level, concluded that prohibition does not lie with respect to Trump's immunity argument. So the preclusion of the evidence is not going to be applicable to Trump. So the evidence comes in language that has now been contradicted and destroyed by the Supreme Court. The first department suggested that a direct appeal after the case is over would protect Trump's rights. And that they said there is a need for pretrial review. Oh, he's saying compare. Okay, so never mind. So in other words, Trump can deal with this after the case is over. We want to deal with the case before the case is over, but Trump can deal with it after the case is over, which is insane because that's not what immunity provides for. Immunity precludes you from going through the process in the first place. That's what immunity is. You're immune from this. No. You're immune only from like the conviction and jail, but you have to sit through the trial? No. You don't even get charged. So President Trump says, okay, but you can't do that again, essentially. So how about this? On April 15th, the first day of jury selection, Trump's team is making these objections noted, etched in there. Bragg made an offer of proof. So the judge said, well, what kind of evidence do you have about this pressure campaign? And the first category, they said, well, here's the evidence, Your Honor. We're going to show in trial because Trump is now trying to keep this out. So they said, well, what kind of evidence are you going to show? And let me decide. So Bragg came out. Now, the first category of evidence that was going to be this Trump's dangerous pressure campaign was tweets and communications with Michael Cohen by then President Trump, their quote. So Trump was president, talking to his lawyer and tweets when he was president. Sounds like official. Those were communications also via Robert Costello. They said that this was a back channel communication with President Trump, which was also critical to maintain. Now, Bragg argued that these are Trump's own words publicly broadcasted, tweeted out for the world to see. And so Trump should not be able to prevent the jury from hearing them now. So in response, Trump's defense said, okay, well, we're going to say this is immune. This is his official communication. This is an official presidential act. Bragg is even admitting he sends it out for the world to see. Like a president communicating to the public, which is an official thing that the president does. So they said, oh, okay, well, we're going to say that's immune. Like, you can't use that because that's immune. And SCOTUS is going to decide it right now, so you should probably stop what you're doing. But Judge Maran said no. He said, if the argument is that tweets that Trump sent out while he was president cannot be used because they're an official presidential act, he says, I don't think so. It's going to be hard to convince me that something that he tweeted out to millions of people voluntarily cannot be used in court when it's not being presented as a crime. This is the judge reasoning. It's just being used as an act, something that he did, but we'll wait until we get that submission. Wrong. So his analysis is pretty wrong. So following the proceedings, Trump submitted a pre-motion letter saying, well, Your Honor, we're going to reiterate this. We're going to regurgitate this again. We have an evidentiary objection. That was an official act. Trump was communicating publicly through an official communication channel, which means he gets immunity for it. You don't get to go in there and cobble it up and decide what it is. The letter specifically objected to this form being submitted, objected to Government Exhibit 407, 407F and I. We also objected to any witnesses talking about Trump's official acts during the first term. The lawyers did a great job. On the issue of timeliness, Trump said, no, it's perfectly timely. Do you know why? Because a motion to preclude evidence is not a pretrial motion. Alvin Bragg was lying to you, Judge. You probably knew that, but you kind of entertained it. So a motion to preclude evidence can come up at any time. It's not a pretrial motion or something that is limited by those timelines. Now, Bragg also responded to that letter. And in that letter, they said, no. They said Trump had forfeited the presidential immunity argument. Sorry, Trump, you're too late. But they made no serious effort to defend their prior timeliness claim. So they dropped that. They're like, oh, crap, he's right. Oops. So they conceded that Trump could make the appropriate objections during the trial. They said if it's merited. But nonetheless, Bragg, right, and prosecutors have a higher standard and duty of care. We know that they're political hacks, especially in the cases that we cover, but they are not supposed to be that way. So Bragg stubbornly insisted with tremendous and unwarranted arrogance, which is true, that's how they mostly are, and in great tension with positions taken by several Supreme Court justices just days later at oral argument, Bragg came out and said presidential immunity does not exist at all. A lot of people said that because they're idiots. Shocking to me. We had different judges and like Harvard people all over X. It was insane. They all got obliterated multiple times. They also were dead wrong on the Trump removal situation. I mean, it's like unbelievable. There is no corresponding evidentiary privilege as well. And President Trump, they said, was not acting in an official capacity. So they lost on all those. Now, the court ruled on April 19th, after Bragg made that absolutely arrogant and stubborn statement, the court ruled that its reasoning remains the same. Mercon says, that's brilliant analysis. I love that. Well done, Alvin. The court said, we're going to wait until trial, and you can make your objections at that time. So if Bragg submits it, they can object, and then the judge will decide. Now, both of you have already made your arguments in the letter, so the court will decide at the time of trial when the objections are made. So the matter is decided and will not be addressed any further. Okay. So Trump has made multiple objections now on the record. and said, okay, we'll just keep objecting, I guess. And the judge just keeps kicking it down. So then trial starts. Defense counsel renewed the presidential immunity objection at trial multiple times, including right before Hope Hicks' testimony. Now, I think the judge will say this because when we were covering the trial, reading through the transcripts here, we noticed that the judge would at times say things, like specifically in the Stormy Daniels testimony, I can't believe the defense didn't object. And we're all sitting here, the defense did object like 15 times. Did you hear that, Your Honor? So the judge has conveniently forgotten some important components of the trial when it serves him well. So Bragg incorrectly responded that the rule of inadmissibility that Mr. Beauvais just described does not exist and is not a rule, and claimed falsely that analogous case law showed the opposite. And so they're getting into it, right, when trial starts. Trump's defense, Your Honor, objection, that evidence can't come in, presidential immunity. And the government, no, it doesn't exist. It's not even a rule. What are they talking about? In fact, we should have case law that shows the exact opposite. And the judge says, I agree with you. I believe I ruled on this as well. And so the objection is noted, and the court said, I don't think you need to object as to each question. So this is what the defense is doing right now, is they're papering the file, because they know that the judge is going to come back and say, you guys didn't object to keeping this evidence out. They're saying, oh, we sure as hell did, brother. We have been objecting for months, multiple times. You have overruled us every time. And in addition, the Supreme Court granted cert, and there was good cause for the timing of Trump's initial motion. Yeah. So during the testimony, a former Trump organization controller, his name was Jeff McConney, so the government called McConney out. Defense objected. Your Honor, objection. We object to this witness. Why? Presidential immunity. Why? Well, because he's going to talk about form OGE form 278E. Here's what happened in court. Matthew Colangelo, Joe Biden's prosecutor who left the Joe Biden DOJ to come prosecute Trump, said, Your Honor, so for the same reasons I believe we briefed and argued previously, there is no evidentiary inadmissibility doctrine for official acts. Just doesn't exist. And in any event, the regulations require the filing of the form for presidential candidates and candidates for federal office, and for reasons including the purpose of ensuring compliance with conflict of interest laws. And so it is not a document entitled to any evidentiary exclusion at all. The form. Mercon says, I agree. Mr. Colangelo, great job. Your Honor, the same objection as discussed last week, says Mr. Blanche, just continues to repeat it. So again, overruled. Court says, I agree. That was the wrong analysis, Matthew Colangelo. Got that one wrong. But you don't care because you're a hack prosecutor who just is devoted to getting an outcome, regardless of what the law is. So then they brought in Hope Hicks. Now, Bragg used its subpoena power to require Hope Hicks, the White House Communications Director, Director of Strategic Comms, to testify about her time with Trump during his first term in office. At the start of Trump's term, Hicks joined the administration as Director of Comms. In that role, Hicks' responsibility included working to showcase President Trump's accomplishments and the agenda of the administration. In August 2017, she became the White House Comms Director. In January, and between January and March, she worked in close proximity to the Oval Office. In fact, the transcripts say she spoke with President Trump every day. Sounds pretty official, huh? As the comms director, she was responsible for a bunch of stuff. Coordinating communication. She also was making sure that the principals of the agencies and the agencies themselves were prioritizing Trump's agenda, and that we're all working together to maximize the impact of the positive messages. Trying to get out, share more of this with the American people to capitalize on these opportunities to show Trump in a good light, like a comms person should. Now, Hope Hicks testified about her official capacity communications with Trump and the press concerning a Wall Street Journal article that came into evidence at trial. You recognize this? Yeah. Hicks explained that the Wall Street Journal contacted either herself and another press communications team member prior to publishing the story. The article included 2 comments from a, quote, unidentified White House official. So Alvin Bragg brought this in. He elicited the identity of the White House official and asked Hicks the following. And as the communications director at the time, says the government, withdrawn, did you discuss this statement with Mr. Trump before it was issued? Oh, so responding officially to a statement. Yes, I did. Hicks testified that after the article was published, she spoke to President Trump about, quote, how to respond to the story, how he would like a team to respond to the story. In January 2018, the organization known as Common Cause also made a complaint about Trump and Cohen to the FEC. In mid-February, Hicks spoke with President Trump about a New York Times article that included a statement from Cohen. Cohen saying that he had, in fact, made this payment without Mr. Trump's knowledge. During testimony at trial, Hope Hicks testified. She said, President Trump was saying he spoke to Michael and that Michael had paid this woman to protect him from false allegation. And that, Michael felt like it was his job to protect him. And that's what he was doing. And he did it out of the kindness of his own heart. He never told anybody about it, And he was continuing to try to protect him up until the point where he felt he had to state what was true in the story. And he wanted to know how it was playing, said Trump. And just my thoughts and opinion about the story versus having the story, a different kind of story before the campaign, had Michael not made that payment. So Trump is saying, okay, so there's this story floating around, and what's your thought on it? Prior to that, and this is like official communication stuff, right? The White House has a comms department. They have a press secretary. It's what they do. Talk about this stuff and deal with it. Prior to trial, Alvin Bragg, quote, refreshed Hicks' memory about Karen McDougal, Droopy McDougal, who also had a claim against Trump. At trial, Bragg offered a text message exchange between Hope Hicks, the director of comms, and Madeleine Westerhout, who was the Oval Office operations person, that included a message from Westerhout purporting to reflect a request from President Trump. Text, hey, the president wants to know if you called David Pecker again, the guy who worked from AMI, as you recall. Bragg also elicited testimony from Hicks about official capacity, right? This is her job. And she's saying the president, right? She's working for the president. Hey, Hope, did you talk to Pecker on behalf of the president again? And she's the works for him. Hicks said, to be clear, I did speak to Mr. Trump. I was a communications director. This was a major interview. Yes, we just spoke about the news coverage of the interview and how it was playing out. As you do. Now, there may be people who say, well, that's political and that has something to do with the president's personal stuff and not his official stuff. And he said, come on, guys. The president has an obligation to maintain the integrity of his office against the attacks. Joe Biden and Karine Jean-Pierre coming out saying, no, he actually is competent, right? Is him defending, yes, his personal self, but also the presidency. It's about his competency, his integrity, his capacity to do the job. It's all part of the job. So we just spoke about the news coverage of the interview, so it's official. Then, in addition to Hope Hicks, they brought out this other evidence. Now, again, we're asking ourselves, each one of these subcategories, what bucket does this go in? Is this something that is absolutely unofficial, not presidential conduct at all, that if you criminalized it or made it the subject of a criminal prosecution, it would have no impact on the presidency at all, like it's so far removed? Is it questionable? So we start with presumptive. Is it absolute because it's codified and clear? Where does it fall? Does the president have the right to have a staff and communicate with them? And can that evidence be used against him at trial by a hack prosecutor? Supreme Court says no. They say, you guys did that though. You brought in Madeleine Westerhout. She was special assistant to the president. She served as an aide to Trump, variety of titles in the first term, but then she became the director of Oval Office and then special assistant. But like what they did with Hope Hicks, Alvin Bragg used his subpoena authority to require Madeleine Westerhout to testify. Government prosecutors elicited this information from Madeleine when she came in to testify, asked him, what was President Trump, got her to say this, said that President Trump liked speaking with people in person or on the phone. Sounds like presidential duties. President Trump, she talked about, took a lot of calls each day, as early as 6 a.m. The man's unbelievable. until late into the night. Wasn't in bed by 8 like Joe. The complicated process for calling the President of the United States, she talked about, included calls that were more secure that might need to be on a secure line, conducted via the Situation Room. So she set those up. She said Trump did not use computer or email in the White House. He liked hard copy documents. Trump also, she testified, liked to read. Moved his working space into a room off of the side of the Oval Office, which was really his working office, because he wanted to keep the Resolute desk very pristine and kind of keep that more for meetings. Man, I like his style, dude. I like that a lot. Yeah, keep all your trashy, desk disorder in another room. Come into the Resolute desk. It's nice and tidy. How do you like it? President Trump used an organization system and brought a lot of papers and often brought things back and forth to his residence or Air Force One or Marine One. President Trump preferred to sign things himself, she said. Liked to use a Sharpie or a felt tip pen. Typically read things before he signed them. Regarding social media, right? This is all official stuff. She's talking about what he does in the Oval Office. What does he do? How does he work? Got an organization system. All testimony. All should have been precluded. Regarding social media, Westerhout testified that Trump and Dan Scavino shared access to the real Donald Trump account. That's a lot of power. DNY Bragg said elicited that President Trump occasionally dictated posts to Westerhout and asked that President Trump's particular preferences for posting, right? So she testified about a lot of that. All of that came out. All of that was official act business. Never should have come in. Structural problems with the trial. How do you disentangle that from everything else she testified about? You can't. Bragg also elicited testimony from Westerhout, talked about her extensive contacts with the Trump organization, who at Trump's direction, while she was working there, she communicated with. For example, they offered an email exchange in January where Westerhout used her official email account to ask Rana Graff for contact information. She talked to people that Trump frequently spoke to. The president would ask her to initiate calls. And all of this, she testified after she had recently been refreshed by Bragg, okay? So I love how they're including that, because what that means is Bragg is bringing this out. It's his misconduct. He's asking about it. It's all official acts stuff. They also brought out testimony about Jack Smith's office and the congressional investigations and the pardon power. All of that stuff is presidential stuff. By the summer of 2017, the media had reported that Robert Mueller was conducting a far-flung and fruitless investigation into Trump, all related to Russia from 2016. In April 2018, the FBI executed search warrants that went after Michael Cohen. Then, between August and October, Cohen made false statements in private meetings and public testimony before the Senate and the House. At trial, Michael Cohen came in to testify, and he claimed that he lied to Congress because, quote, he was staying on Trump's message that there was no Russia. He also testified, right? So, in other words, Cohen is talking about Trump's official presidential scandal. Cohen also testified that he felt that he needed what Ms. Hoffinger, the prosecutor, described as the power of the president to protect him because he lied to Congress, right? So again, president. The idea with the immunity stuff is you can talk about presidential crimes as long as they have nothing to do with the presidency at all. If the president does something that has literally nothing to do, and you can segregate that, right? So you don't have to talk about the office, the lawyers. Now, if the president stole a candy bar, that's it, right? Nothing comes, or speeding ticket or something. But everything else, they're talking about the power of the president. Michael Cohen's testimony is intertwined with all of this stuff that should be immune. Can't do that. So Bragg also elicited pardon-related testimony. Because, in other words, the president is allowed to pardon everybody. You can't sit in judgment of him, and you can't prescribe motives to the president. Oh, Trump was going to pardon you or pardon this. And so in other words, the president is going to be penalized because you're now talking about his official powers. It's not appropriate at all. And of course, the Supreme Court agreed. Bragg also elicited this from Michael Cohen in an email that Robert Costello sent. Costello wrote to Michael Cohen an email in pertinent part saying, well, what you do next is for you to decide there, Michael. But if that choice requires any discussion with my friend's client, you have an opportunity to convey that this evening, but only if you decide. And they were talking about potential pre-pardons or something, said Michael Cohen. And if they're talking about a pardon power, that directly implicates the president. You have to at least ask if that is protected by immunity. They didn't do that. Huge mistake. They also brought in testimony about Trump's response to FEC inquiries, more official business. On February 6, Michael Cohen texted a reporter from the New York Times. He said, President Trump just approved me responding to the FEC complaint with a statement. February 6, 2018. See that date? Cohen texted a reporter that the president said, you can do some legal work helping me with my presidency, responding to an FEC complaint. Please start writing and I will call you soon. Michael Cohen said that. Bragg offered evidence that Cohen's subsequent public statement about this, and they admitted that into evidence at trial, 2018 evidence. Jay Sekulow subsequently texted Cohen that President Trump says, thanks for what you do helping me deal with my presidency. At trial, Cohen explained that he was instructed by Mr. Trump to keep in touch with Jay because he was in contact with Trump. And Cohen opined that the text message referred to President Trump and that the statement that Cohen was putting out to the press was from him on the FEC. Official stuff. Cohen also testified that he spoke to AMI's chairman, David Pecker, about the FEC. Cohen testified he told Pecker that the matter was going to be taken care of, and the person who's going to be able to do that is Jeff Sessions, another official person at the time. So the government elicited that Trump told Cohen that Sessions would address it. Official actions between the president and the attorney general at the time. Why did any of that come in? Shouldn't have. More evidence that should have been kept out. Bragg also offered evidence of 5 sets of posts from Trump's official X account. In a first set of the Twitter posts dated April 21st, 2018, presidential communications, Trump criticized the New York Times for going out of their way to destroy Michael Cohen, trying to get him to flip. At trial, Hoffinger elicited that Cohen was raided by the FBI. Hoffinger also later showed 21 posts to Michael Cohen, who said that those posts were directed to me, saying, I have you, Michael Cohen said. Trump was posting to get me killed. Bragg also offered evidence about other communications between Cohen and Costello, all official stuff. And in the email, Costello characterized the post as containing very positive comments about you. Cohen testified he interpreted the email to refer to communications from the president, right? Official communications from the president to the lawyer. He said, it let me know I was still important to the team to stay the course and that the president had my back. Now, with respect to the second set of the Twitter posts, Hoffinger also elicited testimony about Stormy Daniels. And through a series of leading questions, Hoffinger then basically testified that Stormy Daniels brought a defamation claim against Trump, which was dismissed by the court, right? And so all of that was probably not relevant, but the judge let it in. Now, Bragg also admitted the social media posts into trial over Trump's objection. You can't have those in. And they said you could. It's about the paralegal. Yeah, they said through the testimony of a paralegal who did not have firsthand knowledge. So they brought in just a paralegal from Bragg's office. And she says, I went and clipped these, as we remember. So you can see the same pattern. They're talking about all of these text messages that should have been precluded. Twitter posts, rather. And they continue. They say the 4th and 5th posts were later dated in August of 2018, again during the presidency. If anyone is looking for a good lawyer, Trump said, I would strongly suggest you don't retain the services of Michael Cohen. The 5th post stated, I feel badly for Paul Manafort and his wonderful family. Justice took a 12-year-old tax case, among other things, applied tremendous pressure on Manafort. Unlike Cohen, he refused to break. Such respect for a brave man. Then they asked Cohen the following question. They said, Mr. Cohen, what, if any, effect did it have on you at the time to have, here you go, look at this, question from the prosecutor, to have the President of the United States tweeting this about you the day after you pled guilty? Cohen said it caused a lot of angst and anxiety. So they're constantly commenting on the presidency, right? And is the president not allowed to respond to his attacks on his administration? Of course he is. So President Trump also made disclosures to government ethics. And we'll fast forward through some of these because I think we get the understanding on this, but they give us a summation. So I think that's actually the final one. But Trump filled out the form, which we talked about. So during the closing arguments, now with all of that evidence that should have been precluded that now has been included, they say the prosecutor repeatedly emphasized all of the inadmissible official acts testimony. In his closing arguments, he said Hope Hicks and Madeline Westerhout, these are people who said damaging and utterly devastating testimony. He called them critical pieces of the puzzle. Shouldn't have never had their testimony at all. He said they had no motive to fabricate anything. He described Hicks as Trump's own employees. He described Westerhout saying that Trump also submitted his own tweets. He said that Trump had a fascinating conversation with Hope Hicks, which we know was official. And at that point in the summation, he read Hope Hicks's testimony to the jury. He said that her communication as his official employee was devastating. He said it came from Trump's own communications director. Immune. Mr. Steinglass revisited this towards the end. He said when the story finally broke in 2018, Trump explicitly told Miss Hicks, that it's better that the story came out now than before the election. Now, regarding Trump's attack on Cohen, Steinglass said that Cohen's lies to Congress had to do with the Mueller investigation and the Russia probe. He argued that Cohen's, which were both related to Trump, he also argued that Cohen's public statement about the FEC was an effort to fall on the sword to protect the president, He made the explicit argument that Sekulow was communicating with Cohen on behalf of President Trump. He said the substance of the calls between Cohen and Trump was basically, don't worry, I'm the president of the United States. There's nothing here. Everything's going to be okay. Stay tough. This is the prosecutor regurgitating what he thinks Trump was saying. Oh, basically, don't worry. I'm the president. I'm going to take care of you. Just lie. Keeps talking about the president. Why? Because he has the pardon power. Right? All of this is like negative towards the president. And it should not be. The president has absolute pardon power. So why can he use that as motivation to get into Trump's mind to say, I'm just going to just lie for me. Everything's going to be perfect. The president has the power to pardon you. So that can't be used against him. So with respect to Trump's Twitter post, Steinglass also reminded the jury of Cohen's opinion that President Trump was communicating with him without picking up the phone directly to send a message to Cohen. Don't flip. Bragg also called attention to Trump's Twitter post here and linked the disclosure of the form that Trump signed. And then they incorrectly, in his closing arguments, said that the clear message from Trump's official act tweets was this: cooperate. You will face the wrath of Donald Trump. All in closing arguments. So we know that at any time, according to New York law, at any time after the rendition of a verdict of guilty, but before a sentence, what can the court do? The court may, upon motion of a defendant, set aside or modify the verdict based on any ground which, if raised on appeal, would require a reversal in the next level court. Presidential immunity issue here warrants that. Saying, as explained below, the Supreme Court held in Trump, prosecutors like Bragg and Jack Smith and Fannie cannot use evidence of a former president's official acts in a criminal prosecution. Can't do it. SCOTUS said so. The prohibition forbids the use of official acts evidence even where the actus reus of the crime at issue is unofficial. The act, which is in criminal law, we talk about a mens rea, guilty mind, and the actus reus, the guilty act. Presidential immunity is absolute with respect to the president's exercise of his core powers. You can't criminalize that because you're criminalizing a core power. That means that you're dividing by zero. Arising from the Constitution and is at least presumptive, which means you start with immunity, as to official acts within the outer perimeter of presidential powers, which is basically as broad as hell. Actions that are not palpably beyond a president's authority, meaning it's actually breaking the law beyond the presidential authority. That would be the far left bucket. So we have the absolute immunity bucket for the presidential core powers. We have official acts, which we have at least presumptive immunity over, and you got to basically prove he doesn't have it. And then, or have an evidentiary hearing to show that, overcome that presumption. And if it's not, it's got to be in the last category. So where presumptive immunity applies in that middle bucket, prosecutors bear the burden. There is a presumption. The prosecution, the government has to overcome and rebut that presumption to show that, nope, they shouldn't be in that bucket. We put them in the middle bucket. Trump has immunity. They have to come out and take it out of there and put it in a different one. We don't start in their bucket and move over here. By showing that a criminal prosecution involving evidence of an official act would pose no dangers to the intrusion on the executive branch. It is broad. But in this case, Bragg has waived the right to seek to rebut the official act's presumption because he rushed to trial over Trump's objection. The purpose of the doctrine is obviously to ensure that presidents can do their jobs. The Trump court at the Supreme Court level addressed this. They talked about the separation of powers concerns. What happens if a president's official acts are criminalized by other entities? In this state level prosecution, there are concerns about the institution of the presidency being dumped over by Alvin Bragg. And so the only thing that we can do here, because this has been such a devastating structural error, the only remedy is to dismiss this case. They tell us the Supreme Court held in Trump, presidential immunity is designed to protect the office of the presidency. Bragg made many bad arguments and got official acts evidence in. But you can't do that because the Trump court broke immunity into two broad categories: core powers, where absolute immunity applies, and outer perimeter official responsibility immunity, which is presumptive. For the official acts outer perimeter, you're entitled to at least presumptive, at least presumptive. Now, the Trump court did not decide whether the outer perimeter test must be absolute or whether presumptive immunity is sufficient, and instead remanded this down because we're going to go back down and see how it goes. It's ultimately up to the government to rebut that presumption. Where the presumption applies, at a minimum, the president must therefore be immune. Oh no, Alvin Bragg blown out. Here, though, any efforts by Bragg to rebut the presumption, he can't do that now. It's untimely. This is so because questions about whether the president may be held liable must be addressed at the outset of the proceeding. So you can't go unring this bell. Having rushed this case to trial, you can't rebut the presumption now. While these issues were under review from the Supreme Court, we told you to slow down. Bragg should not be permitted now to try to clean up his mess. The harm resulting from Bragg's actions is irreparable. Now, future presidents will be unduly cautious. The damage has been done. Under these circumstances, the only remedy is dismissal. And even if this court is inclined to address this by allowing them to try to rebut this presumption, can't do that. Court made clear, courts cannot dig into a president's motives. It's from the Supreme Court in the opinion explicitly. Such an inquiry would risk exposing everybody to attack because they would just say, you got a bad motive. Now, the justifying purposes of the presidential immunity doctrine are recognized in Trump. We saw the case, read through it in some detail. Although Clinton arose, we're going back through other cases. The court they're walking us through the case law. We'll fast forward through this. And those are a lot of the rules. So all of those facts have been in place. We've gone through those. They now tell us here's where they went bad. Bragg literally violated the Constitution by allowing this stuff to happen. All of Hicks' testimony about 2018 is entitled to absolute immunity. You can't have testimony from former advisors probing an official act. That's ridiculous. All of it has to go. White House comms director Hope Hicks, she was a key subordinate of Trump. President can't execute every single law alone, so his conversations with Hicks involved efforts by the president to supervise someone who is wielding executive power on his behalf. That is from his Article 2 powers. Trump relies on the Constitution. He has interactions with his comms director, and so he's entitled to immunity for those conversations. Now, because Trump's convos were based on core authorities, presidential immunity is absolute. We don't need a further inquiry. We don't need an evidentiary hearing at all. Similarly, Hicks was talking to the media, talking about an FEC inquiry, talking about Michael Cohen, talking about speaking to the American people. That is all well within the presidential duties. In fact, in 2018, Trump was working to communicate with the media as president about all of these issues. Trump was providing guidance and information to Hicks so she could communicate these things to the public. Now, the testimony concerned efforts by Trump to work with Hicks to recognize a long-known recognized presidential power. It's called the bully pulpit. In a Clinton case, the Supreme Court recognized that statements by various persons authorized to speak to the president during the presidency arguably may involve conduct within the outer perimeter of the president's official responsibilities. So it counts. Clinton did it. Now, even if the court had strained to give Bragg the benefit of applying only presumptive immunity rather than absolute, you cannot go into the president's motives. Courts cannot do that. Paula Jones alleged that President Clinton, through his White House aides, did a bunch of stuff. We know Clinton was gross. Rather, what matters for the purpose of presumptive immunity is whether a criminal prohibition would intrude on the presidency. Obviously, that would happen. If you criminalize this conduct, Trump can't talk to his comms director? Is that what you're saying? So obviously that can't apply. Now, they say recognizing Trump and his conversations with Hope Hicks, we say all those should be protected. And so they should have been barred from using her testimony at all. There was absolute immunity. They done goofed. Same story with Madeleine Westerhout. Okay, she was a loyal White House aide, and the assistance of close aides is necessary. Even Elena Kagan, a Supreme Court judge, talked about this in one of her law review articles. Oh, Elena Kagan. But Bragg forced Westerhout to provide details of how Trump literally operated the executive branch, literally. How does he run his White House? Talked about national security matters. Talked about observations she made sitting outside the Oval Office. Question to her, Madeleine, did you also make an effort to learn about Trump's preferences by observing him while you were sitting in the Oval Office? This invasive and compelled testimony included information about Trump's official capacity work, his habits, his relationships, his social media. Government asked her about Trump's transportation of documents, talking about calls about secure lines in the Twitter account, all the things. Now, her description of all this is she was talking about core powers of the commander-in-chief. And so all of that entitled to at least presumptive immunity. It's clearly within the outer perimeter. But none of this would be able to be rebutted by the prosecutors. You should have addressed this before, Judge. You didn't do it. They also tried to get in Trump's statements, as we know. During discussions related to President Trump's Twitter account, Supreme Court said context can make clear that social media accounts can purport to speak for the government. So even though it was a personal Trump account, like you had the personal kind of branding behind it, it can be official. President Trump used that account as one of the official main vehicles for conducting official business. In addition to the appearance of the account and the official manner in which he was using it, he also used a White House employee to help him operate it. Scavino, the White House director of social media, works for the White House, employed by the executive branch. were allowed to use it. But Bragg relied on false opinions from Cohen and Daniels to suggest that they were tweets directed at them, that they were, rather than what they were objectively. They were talking to the American people about matters of public concerns and attacks on the White House. The opinions of Cohen and Daniels are entitled to no weight on any of this. They don't matter at all. It's about whether Trump has immunity. It's not overcome because Stormy Daniels got scared. Or Michael Cohen says, we were under attack. Suddenly that breaks immunity? No. Hoffinger used Cohen to say that I was under attack. Hoffinger also, the prosecutor, emphasized the official nature of the public communications, saying, what effect did this have, Cohen, having the President of the United States saying this about you? Which he's allowed to say, right? It's official from the president. Now, while that timing's undisputed, so too should the authority of the President of the United States to comment on and criticize federal prosecutors. That's what he's entitled to do. In other words, like other official acts that they used, Trump's Twitter posts fall well within the core authority of the nation's chief executive. The court said they have power to do this, and Clinton was alleged to have authorized White House personnel and a private attorney to talk about allegations by Paula Jones and other things, and said those conducts may be within the outer perimeter of the president's responsibility, right? The president has to maintain the credibility of the office. You're a high-profile person. You got to deal with that stuff. So the only evidence that they would have to rebut that there is at least a presumptive outer perimeter are lay witness opinions from Cohen and Daniels. But again, that would go into Trump's motivations, and you're not allowed to do that. So they also talk about Trump's official acts in relation to the FEC stuff. Cohen testified that President Trump told him that an FEC inquiry would be taken care of by Jeff Sessions. Whether that's true or not, it's about the president. Assuming this conversation happened, which we don't even concede, Cohen's testimony included information about Trump's conclusive and preclusive authority. And in other words, the president has the power to talk to his attorney general and to his lawyer. He's immune for that. You can't ask what the conversation was for. Why were they meeting? Were they meeting to conspire? Is he allowed to meet with his AG? Yeah. Is he allowed to meet with his lawyer? Yeah, it's immune. As in Trump, Bragg suggested that Trump spoke to attorney general for an improper purpose. You can't read that. Sorry, can't read into his mind. And they also talked about congressional investigations. They say this official act's evidence came in. Cohen sought to justify his perjury on the Robert Mueller stuff by saying he was going to be on Team Trump. That Cohen was seeking the power of the president to protect him. And so he needed to get under Trump's good side, which is why he lied. And similarly, Trump had the form that they wanted to get admitted, even though it was an official form. So use of official acts evidence also happened in the grand jury proceedings. So they also violated this during the grand jury. Obviously, we can't see this because there's some redactions there, but because it's a grand jury, which is secretive. But the official acts evidence was also presented to the grand jury. They can't see that. Court said, you're immune. And so it requires a vacating of the verdict. The trial in this case, they say, to put it mildly, was similarly tainted. In light of the federal constitutional doctrine that came down from SCOTUS, the jury's verdict here cannot stand. The Supreme Court does not allow for overwhelming evidence or harmless error. These are institutional issues. The verdicts reflect a threat to the principles articulated by the Supreme Court. And in any case, because of the peculiar constitutional concerns, these are not harmless error, and presidential immunity errors are never harmless. You can't just write this one off. These are critical issues. Here, Bragg wrongfully and unconstitutionally forced President Trump to litigate official acts at trial. They did it proudly. They did it unapologetically. They did it in a manner that speaks to the political motivations driving the elected local officials responsible for this prosecution. For example, referring to the contested official acts evidence now plainly subject to the Supreme Court, Bragg promised the appeals court that it planned to offer evidence of President Trump's supposed blankety blank blank. The heck is that? They were going to offer evidence of Trump's supposed blankety blank blank. Don't know what it is. Now, that is exactly what happened at this trial in violation of Trump. The result is that it's an affront to many of our constitutional principles, and so the verdict must be vacated. The evidence was weak here, by the way. Cohen's testimony was the only connection of Trump to the charged crime. His multiple felonies, including fraud, cannot be overlooked in this analysis. The case was less than overwhelming. Based on Cohen's plea, a federal judge concluded that Cohen lied again in pleading guilty. Bragg relied on Cohen's claims, and that's all. They conceded they made no effort to present any information from Allen Weisselberg at all. Given the resources, it's only reasonable to confer and to believe that Weisselberg's recollection is not consistent with Cohen's. And Cohen's testimony was tenuous at best. Cohen claimed, so now they're saying, okay, look, we have deleted all of the other evidence. We've dismissed Hope Hicks, the tweets. We've gotten rid of Madeline Westerhout. We've gotten rid of everything. Only thing you have left is this maybe. But Cohen's testimony is terrible. He claimed that Weisselberg turned around during the meeting to relay information to Trump, but that he was not even a direct participant. Cohen also falsely claimed that there was a scheme in the Oval Office on February 8th about recurring payments, but then he said later, please remind me of the monthly amount, right? So Cohen's testimony was inconsistent. Now, Ms. Hoffinger repeatedly asked Cohen to describe the substance of a telephone call with Trump 7 years before the trial started. Given the numerous reasons that Cohen had to be in contact with Trump, toll records about those calls do not corroborate the false and salacious details that Cohen attributed. This reality came to pass during the trial when the defense demonstrated that Cohen lied emphatically about having discussed the details with Trump. We remember that phone call with Keith Schiller. He said, I talked to Trump about this whole deal right then. Turns out, no. Cohen was calling Schiller because some punk teenager was harassing him. Through this false testimony, Cohen again lied, demonstrated again. He's just lying. Little more than a prosecutorial parlor trick, has no weight in your analysis. Now, they also tried to corroborate and rehabilitate this liar, but Cohen lied to the jury several times about the call. He claimed the recording ended because there was an incoming phone call. But the call demonstrates that Cohen did not answer the call. It went straight to voicemail, so that's not why the recording ended. The call, also isolated by Hoffinger in the phone records, went to a different physical cell phone device with a different IMEI number, and then the device that Cohen claimed. So again, we had questions about the audio, and he said, no, it's raw. I didn't do anything with it. So it came from a different phone, or voicemail came from something different. He didn't answer it. He said he did. When the September recording was cut off, President Trump was in the middle in the process of asking Cohen to, quote, check on details that were not captured in the audio file. That's why he cut it off. On cross-examination, Cohen tried to explain that away by claiming falsely. He said, I used the word check because we needed to do it by check. Right. Finally, even if all of the problems with the recording could not be ignored, which they could be ignored, Bragg's theory of the substance of the discussion did not corroborate Cohen's testimony. Bragg argued that the recording related to Karen McDougal, Droopy. It had nothing to do with Cohen's payment at all. And so the case was flawed. Also by the evidence. The evidentiary weaknesses were exacerbated by the fact that Bragg hid the ball about the theory that they could put to the jury until they submitted their proposed jury instructions. They put in a bunch of bad jury instructions. And their tax theory, so they're going through the different, remember they could pick a crime, any crime was what we called it here. They could pick any checkbox that they wanted. One, Federal Election Campaign Act. One was about a tax theory under New York law. And then the other was business records theory, which was like that. We talked about it earlier this week, the Russian nesting dolls, these crimes within a crime within a crime. you can make a felony by combining 2 misdemeanors. So there was no evidence whatsoever that anyone but Michael Cohen knew about the contents of the records that he submitted. No evidence at all. There's no evidence to support any conclusion that there was an election conspiracy. Pecker testified the records were not false, and so none of those boxes could have been checked. And they needed this evidence in order to make their case. They brought in all of this official act stuff because they couldn't make their case without it. They sought to bolster perjurer Cohen to address the glaring holes in their case. That's why they brought it in. They relied on Hope Hicks to argue that Trump was aware of the payments, but that's not all. They say that Bragg presented Westerhout's testimony to falsely detail their bogus charges that would have escaped them otherwise. And so their own closing arguments illustrate it all. Steinglass referred to Hicks and Westerhout employees as providing damaging, utterly devastating testimony. He's called them critical pieces to the puzzle. Couldn't have got it without them. Called attention to Trump's own tweets. And so it had a real causal effect here. The jury listened to this evidence. They cannot disregard it. And so, as was evident, this matters. It was not harmless error. And so for the foregoing reasons, they say this court should dismiss the indictment and vacate the verdicts, all 34 of them, signed by these 2 amazing attorneys, Todd Blanche, shout out, Emile Beauvais, shout out. Outstanding work, gentlemen. Submitting that to Judge Juan the Con Mercan in New York, arguing that Trump's presidency entitles him to official immunity, and that he and much of the evidence in this trial belongs in this bucket. And if it's not in this bucket, it's arguably in this bucket. But the time to have the argument about where this evidence should belong has now expired. They could have waited. In fact, Trump's defense told him to wait. Said the Supreme Court is deciding this right now. What are you doing? But the Supreme Court came back down. They've already taken their actions. And so now Bragg is going to respond to this and say none of that evidence matters. Or if there is evidence in this bucket, that there is alternatively, but Bragg is going to say we've got enough in this bucket. All right. We've got enough here to sustain the convictions, even if we threw all of that out. Trump people are going to say you can't do that. It's already been commingled. Okay. This commingling process is over. It's done. So you don't get to go back and strip it out. Tease the noodles out from the meat sauce. Okay. They're all in there together now. You're not pulling out, oh, this is one official act out of the spaghetti, and this is another official act out of the spaghetti, and putting it back. It's done. You already made the meatballs and spaghetti. It's all in there. So it's a powerful motion. I think it is going to ultimately be dispositive. I do not know that we're going to get a sentencing in here because it's in direct opposition to what the Supreme Court has now ordered, and they barreled through it. They had every opportunity to have an evidentiary hearing or to alternatively to preclude that evidence or to alternatively to stay the case. They didn't do any of it. They wanted their conviction. They goofed big time. They presumed it was all in this bucket, all of it. Turns out almost none of it is in there. And the little bit that might be in there, they just went through, and it comes from Michael Cohen, who's a liar. So outstanding motion, exactly what we wanted to see. It was a nice articulation of what SCOTUS said. It mirrored the language exactly. It put the judge on record to explain that we made our objections well known before we even ever got here. We said you should not be doing this, and you did it anyways. So now the only remedy here is a dismissal of the case, a dismissal of the indictment, a vacating of the verdicts, 34 felonies. Need to go bye-bye. And so Alvin Bragg will respond to this, and we'll have some evidentiary hearings, or we'll have, I think, oral arguments on this in September. Is that the right date? It's going to be a while, but we're going to be here continuing to cover it anyways. And so once Bragg submits his response, Trump will very likely have a reply, and we'll be unpacking all of it. And so, my friends, thank you for joining us as our coverage continues. Wherever it is you're watching this, we'd absolutely love it if you subscribed. And it'd be amazing if you invited somebody that you know in your life who you think might get some value out of the work that we do here and have some fun as we go through this madness. We'd love it if you invited them to come join us, because as we know, YouTube says that we are non-authoritative. They don't really share our stuff all that much. So we appreciate you doing that. And of course, we look forward to seeing you back here on the next one. Now, we're not done yet. We're going to see what you say about all of that. It was a big motion, a lot of reading today. And now we'd like to see what your thoughts are on all of it. And of course, very grateful and amazing donos have come in. Thank you so much for supporting us. And how's Good Lawgic doing? Is he still streaming? I want to see what's up with him. Hopefully he's doing good. And the Alec Baldwin fallout, man, I see that is still coming through. I'm seeing that pop through. Man, what a day. What a Friday, huh? Golly. All right, so awesome stuff. Okay, so my friends, thank you so much for sending these in. And I missed one of these this morning from our friend Chubby on Locals this morning. Said, a split? What kind of split is it? There's no way Joe can do a split. Maybe a banana split, but he's probably going to need a bib for that. But Joe's having ice cream. Comments from Chubby today on the morning Membo stream. I think we were talking about Joe Biden's dementia, as usual. And so we had that one from Chubby. What's going on? Oh my goodness. It's a beautiful Friday. And we have our friends Kitty Cat dancing away over here. Let's pull that open here. It's Friday. Woo! Amazing. So shout out to that kitty getting his groove on. We got this one from Tony Hay Munkets bringing in 5 new membos in the house. Thank you, Tony Hay. Doctor Who Eric's coming in. Moon is here. ISA Project, Carolyn H, LK8019, welcome. We have others shouting out Tony Hay Muckets, and we love Tony Hay for bringing in the newest of membos. Speaking of Tony Hay, here's 5 more coming in. We got Mama Pillows here. Sally McCain, what's up, Sally? We got Arnett S, Trish B, and Maynor, all gifted membos, courtesy of Tony Hay Muckets, bringing in 5 more membos. What's up to our friend Oni, became a new supporter. Hey, new membos, whether you join on YouTube or on Locals, we'll see you tomorrow on Saturday for the members-only morning stream, 9 a.m. Pacific, noon Central. Box Lane Productions says, why did Biden cross the road? Not sure, but we can all be proud of him. He made it across the whole road. On the first try, he walked the whole thing by himself. No one even helped him across. Wow. Good job, Joe. We did it. Hey, Michael O'Grady in the house. Smash that like button. What's up, Michael O'Grady? Oni's here. Good to see you for that one, Michael O'Grady. Rob Price is in the house. Membo for 1 month. Baldwin pulled the trigger. That's all that's needed. He got away with it. The dude killed a woman. Dude shot and killed a woman. And he's free. He's free as can be. That's great. What a great country. Hey, it's terrible, I know. But hey, what's up? Hey, Jennifer says you did a very good thing today, Rob. Well, that's true. I'll tell you, I did actually make my bed this morning. It was a nice feeling. Felt like I accomplished something right out of the gate. Thanks for that, Jennifer. Appreciate you being here. Thanks for the dono. Art P says, if Alec Baldwin had left the USA like he promised, he wouldn't be on trial today. Well, yeah, he probably wouldn't have shot and killed that woman, right? I can't believe he shot and killed a woman. Crazy. Hey, what's up? Spud says, tracksuits and polo shirts for everyone. Tracksuits and polo shirts for everyone. Let's get it, baby. We're going to look so good. Hey, Bob M. Bader. Bob M. Bader says, I'm guessing the bullet didn't fit. Yeah. Yeah, it's interesting. It's interesting. I don't know what happened. Did he put it on? No, he says this doesn't fit clearly. What's up, Stephanie O? Thanks for becoming a supporter. We'll see you on the Membos Only stream in the morning. Same to you, sfc.m in the house. Good to see you. Welcome aboard. Thanks for becoming a membo. Same, Carl. What's up, Carl? We'll see you in the morning, man. We got great new membos coming in. Tomorrow morning is going to be a lot of fun. No doubt. We're going to see what other madness we have on a Saturday. Hey, Box Lane says Biden walks into a bar. Ended up in a hospital. Just kidding. Biden walks into a bar. Barman says, why the dementia? That's a good question. How did he know? Because he walked into the bar? He's like, we have a door over here. Just walk through the door. Stop walking into the bar, Joe. Hey, Sergeant GPS says Baldwin trial just dismissed with prejudice. Amazing. Yeah, congratulations to Alec Baldwin for escaping any justice for shooting and killing a woman. Now, I know it was an accident, but there's concepts in the law that there's really no accidents with guns. Like, guns are built to shoot and kill people. So if a gun shoots and kills a person, like, somebody's responsible for that. Like, all right, like, you just are. Even if it is an accident, it sucks. But you have to exercise under the law, unless you have corrupt prosecutors and a celebrity who is a Democratic donor who, whatever happened, I don't know. But it's very convenient when mega celebrities, all of a sudden, the most corrupt prosecutors exist all over the United States. We cover them here all the time. But they're almost never get cases dismissed unless it's Alec Baldwin. Incredible, right? Amazing. What an amazing story. Knox Bierman's in the house. TGIF all. Yeah, homicide cases do not get dismissed like ever. Yeah, exactly right. It's exactly right. Knox is a defense attorney in Texas. They're going to dismiss it with prejudice because of bad evidence or something like this? Because of failure to disclose? Give me a break. Give me a break. Judges dismiss. They're all, come on. I didn't even see it, but it feels rigged to me already. And the prosecutors probably did hide a bunch of evidence. Do you think anybody's going to be in trouble for that? They're like, hey, dude. They're like celebrating that dude. Hey, dude, our case got dismissed because you hid the evidence that we wanted you to hide so that we had a reason for Alec to dismiss the case. Theater, man, theater. We've seen this before. We saw that in Arizona with the Philip Brailsford case where, you'll see this in like cop shootings, right? Where government prosecutors prosecute a police officer for like killing somebody because they have to, because the public's really pissed, angry. So they do that. And then the prosecutors are like prosecuting these cops. And it's like somebody who's like never prosecuted a case or even went to law school is like prosecuting the case. They're like, wow, an opening argument. What's that? Suddenly they don't know how to do anything. They've never done a cross-examination before. They don't know how to introduce evidence. They're like idiots all of a sudden. Why? Because they're prosecuting a friendly. And suddenly mistakes happen. And there's mistrials, and the jurors can't come to conclusions because the evidence is crap. Strange. Always strange. They're prosecuting friendlies. Nothing goes wrong. Or something goes wrong that's catastrophic that just happens to serve everybody in the place except a dead person. Good to see you, Knox. Says, in Texas, we don't even let people off death row for just a corrupt DA. Yeah, I'm sure. Well, Texas is a little different on that. Texas is like, you guys have like the death penalty for like jaywalking, I think, probably. Whoa there, big fella. Crosswalk right over there. I guess we're not going to make that mistake again. All right, we know what to do. Hey, what's up? Fighter for Street says, we need to find a crime on Elon Musk out. Are you with the Biden administration? Because that's what they're trying to do. And if they don't find anything because he's not breaking the law, they just manufacture it. Yeah, that's kind of their strategy. What's up? Misha says, Rob, George Allen Kelly's case from Arizona, the Arizona rancher, was dismissed without prejudice, and Baldwin's case was dismissed with prejudice. Explain the difference. Well, without prejudice means they can refile it and it can come back. With prejudice means it's gone for good. So Baldwin, again, I don't know what happened today, but I would presume that it was something significant, some hiding of evidence. So did the judge dismiss it and dismisses it with prejudice, or did the government voluntarily dismiss and then the judge added with prejudice, or I don't know what happened, or what the procedural posture was, I don't know. But one can come back, one cannot come back is the short answer on that one. But it makes sense. Yeah, George Allen Kelly, of course, was just a man defending his property and his livelihood. Baldwin, though, so George Allen Kelly's case can come back. Baldwin's cannot. But Baldwin has made some pretty bad movies, and George Allen Kelly is not. Former says, Baldwin's charges being tossed are a good thing for former and future POTUS Trump. When all of his charges are tossed, all he has to do is point to Baldwin and say, see, we are both being treated equally. That's one way to look at it, former. I don't know if that's going to happen, but I think Baldwin was shown a lot of favors that Trump has not. I don't think they're being treated equally, but I think I understand your point. What's up? Eniax says, after Baldwin's dismissed case for killing someone, don't you think Maran will sentence Trump to prison? These people are out of control. I don't know. We were talking about this today with Stephen Gardner, which will be released soon, I'm sure, on his channel. So make sure you're checking his channel out. But I don't think that they can put him in prison now. I don't think that they can even sentence him now. They're going to have a real hard time doing that. And SCOTUS just gave them some serious talking to. So, yeah, they're going to be hard-pressed to put him in prison. They'd love to. I think Maran would love to do it, but I don't know that they can. I'm not sure the sentencing is going to even happen. What's up? They'll just continue it. They'll drag it out. They'll postpone it. They'll have hearings on it. But ultimately, Trump will win. Then they'll nuke it. We'll get a resolution after the election. Box Lane, how do you put Biden in a fridge? Open the door, put Biden in the fridge, and then close the door. Well, that's funny. Yeah. And he wouldn't be able to get out. He'd probably just follow you right in there. Maybe that's what they do. Maybe that's why he goes to Delaware for so long. They're like, we don't know what to do with the guy. It's kind of like a dog in a playpen, or a kid in a playpen, rather a dog. You know, you put dogs like in a carrying cage, like when you're transporting somebody. You know, what do they call it? I can't think of it. But same thing for Joe. And that way it preserves his face and his deteriorating corpse. They just put him in a fridge. That makes sense. Hey, what's up, Tony? Hey. Gifted Amembo Archangel, welcome aboard from Tony Hay. This one from Cowboy Rob says, there is nothing that is harmless error when it comes to a former president being prosecuted while he's running. It's all election interference. You're right about that, Cowboy Rob. They made the same point. And it was done by design. The whole thing was birthed out of a desire to stop Trump. Lobo, what's up, Lobo? Thanks for becoming a supporter. We'll see you tomorrow. Same to you, Bonnie E. Welcome aboard. Man, we got some new Dono supporters in the house. Great to have you guys. Look at this one from Sheila the P. Sheila the Pooh, a million hugs to you. Bringing in 10 new membos. Sheila, what's up? Francis W. coming in. Stop sniffing kids, Joe, is coming in. Matt and Robin's Carp Adventures are here. What's up, Karma Plushie? Gyro P gifted. Skada, Gen X Ben, Mr. Cranky Pants is coming in. Freeman Jack, Miss Irradio, and others. Doris N gifted a membo courtesy of Sheila P. Lots of shout outs to Sheila. Thank you, Sheila, for being a membo and bringing in 10 new membos. What's up? Hey, Drek Novisky says, be nice to your HVAC techs, man. It's still July. It's getting hotter by the day. We lost 3 HVAC technicians today. It's hot out there, honestly. And give them some water, by the way, also. Ask them for some water. They usually decline stuff like that. I've noticed that a lot more lately. I'm always offering people things. Would you like some water? Would you like an energy drink? Would you like a sparkling water? Would you like this? No, I'm good. No, I have one. It's right here. No, I have one in the car. I'm going to give you a free one. It's right here. Here, take 2. Take an energy drink. Take this. I'm good. It's in the car. Okay. I don't know, man. When I was cleaning pools, they're like, would you like, yes, anything. Whatever you have, I'll take it. I don't care. You know, I want to show you a broken pipe. Ugh. That's not what I wanted. Okay, thank you, Drek. Be nice to your HVAC people. Hey, PNW, Pacific Northwest Farm Dog in the house, says Baldwin prosecutor pulled a fanny and took the stand. Oh my gosh. It sounds like it was a disaster today. Wild. Alec Baldwin from The Edge, 1997, plays himself. Hilarious, hilarious comment. That was a good movie, actually. I really liked that movie. The Edge, it was good. Knox is here. Okay, link this with me. Knox Bierman says, White House pushed the conviction, as we know, but perhaps the debate was purposely scheduled early not to replace Biden, but because of the strong likelihood of the finding of the presidential immunity. So even though they knew that Biden was a potato, they hoped he could scream convicted felon enough as that it did not matter. Yeah, I think there's a lot of truth to that. I think that the lawfare operation was intended to create a shiny object that they could point to. All of Joe Biden's falls and failures, they would just point over here to something else. Now, they haven't mattered all that much. So now they're recreating Plan B, which is Project 2025, and they're talking about that. But yeah, they needed something else to talk about. And they were just trying to label Trump as a felon, hoping that that would be enough. Doesn't look like it's going to be. Good to see you, Knox. Thanks for that. Venus Gonzalez says, hit that like button, subscribe button, and show Rob and his great crew some big love. Thank you, Venus. We all appreciate that here. Thanks for that. And thanks for the great reminder. Box Lane Productions says, knock, knock. Who's there? Putin. Putin who? Zelensky. That's a Joe Biden joke if I ever heard one before, because that actually happened in real life too. Thanks, Box Lane. Leonard, what's up, says, what chance does a poor person targeted by a corrupt government have? Zero. Absolutely zero. There is zero. I see it. I've seen it. I've represented many people. And when I was first getting started in the law, I did a partial government contract at my first law firm. I didn't have the contract, but they did. And so I would do some work on it. And it was very interesting dynamics there. Yeah, very interesting dynamics. Not much opportunity. Now, shout out to our public defenders who are out there helping people who need it. But it is, yeah, I mean, if you're in a criminal case, but let's say if you're not in a criminal case and you cut the wrath of the government coming down, whew, it's rough. Cowboy Rob says, I wonder why Hicks or Westerhout didn't claim executive privilege. Well, I think they probably did. I think it was invoked. But I think that they just dismissed it out of turn with the immunity stuff. And the Supreme Court didn't really talk about privilege, but they did talk about immunity. Yeah, what's up? Cowboy Rob says, also, I wonder, why couldn't he have just said, anything that happened after January 20th, 2017, I'm invoking executive privilege. Well, there have been many other courts have said that he can't do that. Even, in fact, I think Biden said he can't do that. They tried to do the same thing with him, for example, with Steve Bannon and with Peter Navarro. Remember, they invoked executive privilege. Trump said, I'm invoking it on their behalf. You can't talk about stuff. They said it doesn't apply. And they charged them and prosecuted them anyways. So I think it's the same thing. They say it doesn't apply to him. And that hasn't been an appealable issue that we've dealt with thus far, but immunity has. But it's a great point. Tyler, thanks to minor prosecutorial misconduct, Alec Baldwin has gotten his case dismissed. This just goes to show how wrong the Trump prosecutions are. Yeah, I don't even know what it was. What bit of evidence were they hiding? Was it like a slip of paper, like a sticky note? Defense is like, we didn't get a sticky note. And they're like, oh no, you're right. We forgot to disclose it. Case dismissed. Yeah, right. All right, Milo phone bill. Has President Biden ruined his personal brand, his party's brand? What you do speaks so loudly that I cannot hear what you have to say. Hatch is here. Says, best legal education on any platform. Thank you for what you do, sir. Thank you, Hatch. Thanks for watching on Rumble. Shout out to our Rumble friends. And thanks for the nice dono, my man. I do appreciate that one. Hey, apparently Trump posted this one, I think. Generic Derek shared this one. Hey, play along at home. You have an E, you have a L, you have an N, you have an S, and you have a Y. Joe Biden says, ding, 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 I'd like to solve. Okay, Mr. President, go ahead. Putin! What is Putin? We're all going to die. Philip, what's up, Philip? Gifting 5 membos. Bobby B coming in. We got Law in the house. What's up, Chippewa Joe? Arkansas Labs in the house. And GM got gifted a membo, courtesy of Philip H., who is also a membo. Thank you, Philip, for bringing in our new membos. Milo Phone Bill says, yeah, AT&T's call recording database was hacked October 2022. It was just reported today. Why the 2-year delay? Biden's burner phones were allegedly on AT&T's network. Is this report of hacking a preventative plausible denial? Very curious. Family Shopping on Rumble says, Rob, please interview Garland Favorito from Voter, Georgia. Sounds like an interesting fellow. Thanks for the suggestion, family. We got Milo Phone Bill says, what's the deal with this person? Megan Kahn. I don't know what the deal is. Good question. Mima says, gifted 5 membos. Ray Gould is in the house. G Sharkman got gifted a membo. Right supremacist in the house. That's funny and a little dangerous. Adam is in the house. Good to see you. Welcome aboard. Gifted membos courtesy of Mima. Good to see you, Mima. Thanks for bringing in 5 new membos. What's up, Black Dragon? Welcome aboard. Great to have you as our newest supporter. We got Original Easy says, this Supreme Court ruling should apply to whom executive privilege was extended. Should apply to them as well. Eddie Block Films in the house, you know who he is, says, Biden is live at the Trump rally. I wonder why they put mostly live at a Trump rally. I wonder why they put mostly black people behind him today. Maybe trying to make up for not hugging that other lady. Yeah, good question. So this is Joe? Yeah, you're right. There is mostly black people behind him. Motown for Joetown. I don't know what that event is. Sheila P. New membos coming in courtesy of Sheila P. What's up? Pablo Acqui. We got Breath Stealer in the house. Kenny Lang, Austin Libby, and Rick O'Shea. Gifted membos courtesy of Sheila P. Thank you, Sheila, for bringing in new membos. We got this one from Den the Man. Den the Man in the house. Good job, Rob. Trump 2024. Thank you, Den. Thank you for that one. I agree. Trump 2024. We're on the train. What's up, Ella? Says, will Mercan drop the case? Then what? I think he'll hold on to it for dear life. He'll hang on to it till the end of time, as long as he possibly can. But I don't know how he sentences him. I mean, he might sentence him just out of spite, but Trump will immediately appeal it. And if they sentence him to jail or something, in spite of the fact that they just dumped all over the Supreme Court, that's like it's like open mutiny against the Supreme Court. I don't know that they can even do that. And they might be furious. I mean, they might step in if they did something like that. So I think SCOTUS knocked them back into line, to be honest about it. We'll see. What's going on? We got this one from Barb Loves Alaska. Says, thanks, Rob, for helping Joe over the line. Oh, man, Joe's the best. We love Joe. Joe's amazing. You're all awesome, chat. Barbs, you're amazing. Thanks for sending some love our way. Very generous of you to do that. But all glory be to Joe on this one, man. He has earned it. He does great work. He got over the line himself. And my point earlier was, if you haven't watched his stuff, like if you went over there to just to subscribe, like, thank you for doing that. But check him out. Like, I mean it, check his content out. It's good stuff. And he's an attorney. He's very smart. He did some really great work. We've talked about him a lot here. We did a full segment on his petition. I mean, he was fighting on the Mercan case, fighting to get Trump ungagged there, since he's got a press pass in New York. I mean, he does great work. So we're happy to support Joe, and really glad that he's getting some of the love that he deserves. He's awesome. What's up, Jack Mack? Says, Rob, I think YouTube is mistaken. I think you're pretty authoritative. Me too, Jack. I do too. Especially since you're often using primary references in your analysis. I find you to be a pretty reliable source, LOL. Yeah, I mean, tell me about it. It's like, okay, who's more reliable, YouTube? Is it the dude who puts the actual document on the screen and reads it to you? Or is it Jake Tapper on CNN, who's been wrong about basically everything and couldn't even recognize that Joe Biden has dementia for the last 3.5 years? Who's more authoritative? I don't know. YouTube does, though. It's not us, apparently. Hey, we got a new baby in the house. What's up, Linda Hunter? Full term baby with a nice kangaroo emoji for actual crimes. Oh, kangaroo court for actual crimes. Yeah, good to see you, Linda. Full baby. Newest watcher in the house. We got a live one, my friends. Thanks, Linda, for being a member for so long, 9 full months. And we're going to have many more. I can feel it. What's up? Chubby says, Alec Baldwin case, clearly not yet another prime example of the two-tier justice system. Nothing to see here. Yeah, and I hope my hot take is right on that. I mean, I'm pretty sure it is. Haven't followed it at all. But I think it's going to be, yeah, it's about what we expected. Baldwin's going to go free. What a victory. Words mean things. Good to see you. Says, hi, Rob. Just sending a quick lurking fee so you don't forget how much we love you, even when we can't hang out in the chat. Chat, you're awesome and very much missed when we have to just listen. We miss you, Words. It's good to see you. Thanks for saying hello. And we appreciate you jumping in the chat whenever you can. I'm a big lurker, too. So I really can't say much about the lurkers because that's kind of how I am. So thanks, Words, for jumping in, saying hello. It's a beautiful Friday. Hopefully your week was amazing, and it's great to see you. Gypsy Moon, Membo for 4 months, says Baldwin is proof that the elites get away with murder. He literally he had a gun, and from what I read, he pulled the trigger, and she's dead. And he has no charges, no conviction at all. Literally got away with murder. But they wouldn't say it's murder. So he would say, okay, it's just an accident. Very convenient, isn't it? Convenient. Hey, Gypsy Moon, thanks for that. Jokul Gaming says the special prosecutor didn't bring some evidence that she thought was not associated with the case. 4 bullets that were not the same and never were on the site that claimed she hit it. So the special prosecutor didn't bring some evidence that she thought was not associated with the case. 4 bullets that were not the same, never were even on the site that claimed she hit it. Interesting. I'll check it out later. I'm sure it's a scam. What's up, Just Rhonda? Membo for 4 months. says, time has flown. Fastest pregnancy I've ever had. Just right. We popped one out after 4 months. That is fast. It's like what, rabbits or something? Amazing. Well, welcome aboard. We'll take them. Thanks for that, Just Rhonda. Hey, Dolphin Fan is the man. Bringing in 5 more membos. Brian R's coming in. We got Michael L. We have Storm Warning, Grant R, and Rebecca C. Gifted membos, courtesy of Dolphin Fan is the man in the house. Lots of love going to Dolphin. Thank you, Dolphin. N. Doug. What's up, N. Doug? Over on Rumble says, thanks for the extra push, Rob. Joe made it. He's very appreciative. He had to go at 5, so didn't really get to celebrate. Oh, that's right. Yeah, that's right. That's right. It's Friday. Yeah, so awesome. Well, it's a great way to end the week. So shout out to our friend Joe. Glad that got done. He's awesome. So he's doing good work, and I'm excited for people to get to know him more. Life Matters. What's up? Welcome aboard as the newest supporter. Very nice to have you. We'll see you in the morning. We got this one from Cowboy Rob says, oh, executive privilege didn't apply to him because he's a Republican. Yeah, and they also breached all of Trump's privileges, to be honest. They breached his attorney-client privilege as well. You remember Judge Beryl Howell in D.C., right? He doesn't have executive privilege. He doesn't have attorney-client privilege. He has none. They shattered all of that. And this one from, I see, Rhonda says, no, this is the fastest moving pregnancy. Oh, I see. So we're already 4 months in. I got it. I see it, Just Rhonda. I got it. Makes a lot more sense than we already gave birth. I got it. One old guy's opinion says Baldwin, a lifelong Democrat, gets a dismissal in court. Wild in a Democrat, super majority state. Trump, who walked in entertainment circles, does not. Dismissal of Baldwin because of crooked prosecutors. Trump's Democrat prosecutors are not crooked. Yeah, I mean, talk about hiding evidence. Talk about a corrupt indictment. I mean, we have all of that in every other Trump case, but they bend over backwards to make excuses for themselves. Fannie can stick around. The judge says, I don't know. There's an odor of mendacity. Here, Stephen Mosher says Fannie is selling an eau de mendacity, right? It's like an odor of mendacity, but I think that's like fresh, right? Eau? How do you say that? I don't know how to say it. But it sounds fancy as hell. That's why I don't know how to say it. But it's an odor of mendacity, right? It's like a perfume that fancy people wear. But you're absolutely right, Stephen, and it stinks, man. It's terrible. Hey, Kepaloose says, Rob, can you tell my brother Adrian and his wife Amanda happy anniversary? I would love to wish Adrian and Amanda the happiest anniversary that they've had since last year. I hope it's outstanding. I hope they celebrate doing something amazing for each other, bursting with love, and they have a great time later tonight, too. Happy anniversary, you two. Have fun. What's up? We got Dan Sundin. Says all those electric vehicles are going to be assembled in Mexico, not in Michigan. That could be true. That sounds, I don't know. That might be right. I don't know. Knox says, someone reminded me of this one, sleeping and stinking his way through the climate summit. Oh, stinky. Camilla Parker Bowles, which almost looks like bowels, cannot stop talking about the unexpected gas emission from U.S. President Joe Biden at the Global Climate Change Conference. Talk about climate change and greenhouse gases. Yeah, that stinks. That's terrible. And this one from Libby says, do you think that they will replace Biden? Long story, I think no. I think the answer is no. I think that he's going to weather this storm. They're going to just try to shove him through. I think so. I don't know. I hope so. I hope they keep him around. There's a lot happening behind the scenes, no doubt. If they do make a change, I could see something happening at the convention, but it would be a bloodbath, I think. It would not be good. So I think that they're going to keep him. I hope they do keep him, and I think that they will keep him. Because I don't think he's going to go, quite frankly. What's up, Andy? Says, bringing in 5 new membos. Thank you, Andy, for doing this. Bringing in 5 membos. Melanie H. got one. Goodness and Mercy. Thomas C. Silius in the house. And Carrie, the cat mom. Great to have you bringing in new membos, Andy. Thanks for doing that. And so, my friends, incredibly generous. Thanks for supporting us on the day. It's been a beautiful Friday, and I thought it was a very fun read. So I'm glad we got to spend the time together doing all of that. Let's say what's up to some friends on X before we go on over to locals to debrief and hang out. for our members only after party on Locals. Let's see what's cooking. Over on X, we had some comments from Fred Pedamonte. Yeah, here we go. Some other comments. Says, I watched the Baldwin trial. You have to see what happened. We'll never see that again. As much as I dislike Baldwin, law enforcement and prosecutors seriously screwed up. I don't doubt it. It's just interesting. I'm sure that's true. I just think it's very curious how it happens with Alec Baldwin, and his case gets dismissed, no one else's. Glocky says Baldwin walks free after shooting 2 people, unaliving one of them. Trump is literally facing a century behind bars because Democratic judges and prosecutors just ignore the law and the precedent. Pretty bad. What's up? Glocky shouting out the following program. Good logic. Shout out a bunch of memes over there from Glocky. And there's some good memes over there. A lot of good memes over from Glocky. And thanks for those. John Devan, nice to see you. And that, my friends, is what's happening over on X. And so some great stuff over there. Thanks and shout out to all of our friends on X following us at Rob Govea ESQ. We are going to head on over to watchingthewatchers.locals.com. And if you're a membo on YouTube or on Locals, we'll see you tomorrow for the members only Saturday stream. 9 a.m. Pacific, 12 noon Eastern. It will be a ton of fun, as always, and we hope to see you there. We've also got our website, robertgovea.com and watcherlodge.com. More being worked on over there. But today, we want to shout out our mods and our meme smiths who keep things nice and orderly. In the house, we've got K-Bean. Shout out to Just Cause, Play It Hooky, Ronnie Cole, Zach Nichols, Janek, Dog Digger, Economy Pilot, Donut Mind Me, Carrie B, Zulu, and our friends Sleepy Dog Lee, Nathan, N810, Geegum Geegum, Glocky McLock, and Elliot, our Doc Master, all in the house. And my friends, it has been a beautiful Friday and an amazing week. I hope your week was incredible. And I hope that your busyness is coming to a close because it is the weekend ahead. And I hope that this weekend you're able to unplug from some of this political madness that we spend so much time on. Spend some time with friends and family, the people that we love. Get outside, get some fresh air and vitamin D so that we can all, speaking mostly about myself, rejuvenate our souls and our spirits so that when we come back on Monday, we are rocking and ready to go. Mima says, have a great weekend. Sweet watching the Watchers family. See y'all on Monday. Sending lots of love from Mima. A beautiful exit message because we do need to come back here on Monday to get into it again. And in order to do that, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We got 2 final comments. MJ Powell is bringing in new membos. SB Farmer got a membo. 5 gigahertz got a membo. 3Bs. Linda D. Joshua Smith. White Rabbit's coming in. Bridget C. Patrick S. And Bat Lady, along with Alicia. All gifted membos, courtesy of our friend MJ Powell. Thanks for doing that, MJ. And last comment was from Will Crump. Says, what do you want to bet that Chutkan will rule everything outside of the official duties and that will have to be appealed? I think the likelihood of that, Will, is high. And they'll do that. So that case is not going to go anywhere. And by the time that happens, hopefully Trump's the president so that he can just dismiss those cases outright. And they'll cry foul over that, but we'll know Jack Smith is illegal and unappointed anyways, and Trump's victory will be so resounding, we'll be ready to make those cases go bye-bye. So that will be happening. Thanks, Will, for the final dono. Thanks, MJ, for the final membos. And my friends, I hope you have a beautiful Friday night, an incredible weekend. You get out there, you get after it, you make it a great weekend. We'll see you back here on Monday. Bye-bye.